Financing the aircraft, collateral perfection, and why records matter. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now, let's begin with the first truth in large turbine aircraft finance. The lender is never financing just an airplane. The lender is financing the aircraft, the engines, the records, the title chain, the operating plan, and the legal behavior of the people involved. In FAA terms, a large aircraft means an aircraft more than 12,500 pounds, maximum certified takeoff weight. For many business jets or other large turbine aircraft, the threshold is crossed immediately. That matters because large aircraft transactions trigger regulatory concepts that smaller aircraft owners often never confront with the same intensity. The legal spine begins with recordation. Under 14 USC Section 44107 and CFR Part 49, the FAA maintains the federal recording system for conveyances, leases, and security instruments affecting aircraft and certain engines, propellers, and parts. The federal system is not a decorative filing cabinet. It is the place where title and lien priority become real. And the warning is simple. If you have not recorded properly, you may discover too late that you do not have the priority you thought you bought. The Supreme Court's decision in Philco Aviation versus Shackett remains and often the memorable example. The court made clear that the federal recording system preempts state law approaches that would allow undocumented or unrecorded transfers to defeat innocent third parties. In practical terms, a handshake may transfer possession. It does not safely transfer priority. There is a second point practitioners sometimes miss. FAA recording is important, but FAA recording is not title insurance from the government. Under 14 CFR Section 9049.17, the recording of a conveyance is not a decision by the FAA that the instrument actually affects title or an interest in the aircraft. In other words, filing is essential, but filing alone does not cure bad drafting, missing authority, broken entity power, or a defective chain of ownership. That is why disciplined due diligence matters so much in large turbine deals. Before money moves, counsel and lenders should test at least 6 things. Who owns the aircraft now? Whether the seller can actually convey it, whether every prior release has been properly recorded, whether the engines and installed equipment are described correctly, whether the maintenance records support the represented status, and whether the proposed use of the aircraft will fit the financing structure. The maintenance point is especially important. Under 14 CFR Section 91.403, the owner or operator is primarily responsible for maintaining the aircraft in an airworthy condition. That matters not only for safety, but for collateral value. In large turbine aircraft, missing logbooks, unresolved airworthiness, or AD history, questionable component traceability, or unclear inspection status can destroy financeability faster than a minor cosmetic defect ever could. AOPA Finance put the point in practical market terms in 2025 when it explained why lenders often insist on engine maintenance programs for jets. Much of the residual value in older turbine aircraft may sit in the engines, and a current transferable program reduces the lender's exposure if the aircraft is returned to the bank or lender. That is not merely a convenience issue, it is collateral discipline. There is also an international dimension. For Cape Town eligible airframe and engines, the FAA explains that the international registry is an additional filing located location for qualifying assets, including prospective interest. That means sophisticated finance or large turbine aircraft often require counsel to think in two systems at once: the domestic FAA recordation and international priority protection. Here's a memorable point. In large turbine aircraft finance, the metal flies, but the paperwork decides who gets paid. A simple example here helps. Suppose a borrower acquires a large cabin jet through a newly formed special purpose entity. The term sheet is signed. The bank wires funds and everyone celebrates the closing. But the bill of sale is inaccurate and the security agreement does not match the debtor name exactly. A prior release was never filed and the engine serial numbers are sloppy. In conversation, that still sounds like a closed deal. In litigation, it sounds like an invitation. So the first job in aircraft finance is not to admire the aircraft. It's to make the asset legally recognizable, technically supportable, and recordable without ambiguity. In short, large turbine aircraft financing starts with a basic discipline. Know what the collateral is, know how the priority is protected, and know whether the records tell the same story as the purchase price. Remember this and take this away. In aircraft finance, the jet is the headline, but the records are the collateral. Structuring the deal: loans, leases, operational risk, and large aircraft rules. Now let's turn to the second major issue: how the finance structure must fit the way the aircraft will actually be used. This is where otherwise sophisticated clients can get in trouble. They negotiate rate, amortization, reserves, guarantees, and prepayment language very carefully. Then they treat the operational structure as an afterthought. For large turbine aircraft, that's backwards. The operational structure is often what determines whether the financing remains stable or it blows up. Consider the difference a straightforward secured loan, or the difference between a straightforward secured loan and a leasing structure. A loan may be documented as a note, security agreement, guarantee package, and FAA recorded conveyance documents. A lease may shift tax, accounting, liability, and residual value assumptions. But under the FAA regulations, neither label answers the most critical question: who has operational control? FAA Advisory Circular 91-37B is indispensable here. The FAA explains that truth in leasing requirements apply by regulation to aircraft weighing more than 12,500 pounds. And the agency emphasizes that leases and conditional buyers must understand operational control before entering the arrangement. In other words, the rules exist because the FAA expects confusion precisely where money and operational authority intersect. Under 14 CFR 9123, parties to a lease or contract of conditional sale involving a U.S. registered large civil aircraft must use a written agreement containing the required truth in leasing clause. Identify the maintenance and inspection status for the previous 12 months. Identify the person responsible for operational control, and provide advance notice to the FAA before the first flight under the arrangement. This is not clerical trivia. It is the registration or the regulation telling you where the legal pressure points are. Part 91 subpart F matters as well. Section 91501 applies additional rules to large turbine, U.S. registry and turbojet-powered multi-engine civil airplanes of U.S. registry. This is why large turbine aircraft structures often involve time-sharing agreements, interchange agreements, joint ownership agreements, charter management, or pure dry leases. that must be handled with precision. A real world example, it drives this point home. The question often arises, why? We will just put the aircraft in an LLC, have the management company schedule it, and dry lease it when needed. That assumption or that arrangement can describe a lawful structure. It can also describe an unlawful one. The answer depends on who selects and controls crew, who has authority to initiate or cancel the flight, who bears maintenance responsibility, as well as who can say no to the principal, and whether aircraft and crew are really being packaged together. That is why large aircraft finance counsel must care about the same questions that enforcement counsel cares about. If the lessor, management company, and pilot source operate as a single commercial machine, while the paperwork says the lessee is in control, the documents, they're not reducing risk. They're just storing it. The North Carolina dry lease case announced by the Department of Justice in March 2024 is a good cautionary example. The government alleged that the defendants operated more than 150 paid passenger flights through sham dry leases that were in substance wet leases, and the matter was resolved with a $700,000 civil penalty. Whether one calls that a leasing problem, an operational problem, or an enforcement problem, it all begins as a structuring failure. Large turbine aircraft also raise an asset planning issue that clients underestimate. Engines are often their own legal and financial universe. FAA and Cape Town rules separately recognize certain engines as recordable collateral. Market participants therefore pay close attention to engine serial numbers, maintenance program enrollment, reserve exposure, and transferability. On many older jets, the engines are not accessories to the deal. They are the deal. Here's something to remember, something to take away. The financing documents should not tell a different story than the flight department. A second example for emphasis here helps. Suppose a borrower finances a super mid-sized jet through an owner trust, grants a security interest to the lender, places the aircraft with a management company, and expects occasional reimbursement under Part 91, Subpart F. On paper, each piece may be familiar, but if the trust documents, management agreement, lease language, insurance provisions, scheduling practice, and actual trip approvals do not align, the structure becomes more fragile exactly where the lender expects certainty. The right approach is disciplined alignment. The ownership vehicle, financing documents, recordation package, registry filings, lease documents, insurance endorsements, operational manuals, and actual conduct all need to tell the same story. Because in this part of aviation law, structure is not what the binder says. Structure is what the aircraft actually does. The bottom line is that large turbine aircraft finance is never purely financial. It is transactional, regulatory, and operational all at once. Here's something to take away from this and remember. The best aircraft finance structure is not merely bankable, it is operable. Where enforcement and real losses usually arise: illegal charter, maintenance pressure, and sanctions. Finally, let's discuss the issue clients usually feel only after the financing closes, where the real enforcement and loss exposure most often arise. The important point is this: most enforcement connected to financed large turbine aircraft does not arise because a promissory note was drafted badly. It arises because economic pressure changes operational behavior. The first and most common danger zone is illegal charter and disguised compensation for higher activity. When an owner wants revenue to offset carrying costs, When a management company wants utilization and when passengers want lift without charter level friction, the temptation is to stretch a dry lease, a time-sharing arrangement, or a management structure beyond what the rules allow. That is why the paradigm matter remains such an important example. In 2021, the Department of Transportation entered a consent order finding that Paradigm Air operators engaged in air transportation without the required economic authority, directing it to cease and desist and assessing a compromise civil penalty. The order is especially useful because it shows how regulators analyze conduct in the real world. Holding out, demonstration flights, broker involvement, and revenue activity can matter as much as what the contract is called. The same lesson appears in FAA Safe Air Charter guidance and in the government's sham dry lease cases. In other words, many aircraft finance disputes become enforcement matters when owners try to convert an expensive private aircraft into a quasi-commercial revenue asset without building a lawful commercial platform around it. The second danger zone is maintenance under financial stress. Cash flow pressure does not repeal 14 CFR section 91.403. The owner or operator remains primarily responsible for airworthiness. And under 14 CFR section 43.13, falsification or alteration of maintenance records can support certificate action. In finance-driven disputes, I often tell clients this: the law is remarkably unforgiving when someone tries to solve a liquidity problem with a logbook. A practical example is easy to imagine because it happens in many forms. A borrower is approaching a major inspection, engine event, or program true-up. The aircraft is valuable, but only if the records remain clean and the maintenance status remains current. Someone delays required work, overstates status to a buyer or lender, or cleans up the books after the fact. Now, that's no longer just a technical discrepancy. It becomes a regulatory, civil, and even criminal problem very quickly. The third area of concern and danger zone is international movement and sanctions compliance. BIS states that aircraft manufactured in the United States or foreign manufactured aircraft containing more than 25% controlled U.S. origin content can be subject to license requirements if destined for Russia, and BIS has publicly identified commercial and private aircraft involved in apparent violations. In a large turbine context, that means lenders, lessors, and operators and principals all need to care where the aircraft goes, who controls it, and who benefits from the flight. Those issues, they're not abstract. A cross-border aircraft can expose counsel to export control, sanctions, repossession, insurance, and registry questions all at once. A financier that understands only that the note and not the mission profile is underwritten is only looking at half the transaction. So where do most serious problems arise? Not from the existence of financing itself. They arise, again, at the seams between ownership and use, between lease language and crew reality, between maintenance budgeting and airworthiness, and between cross-border movement and compliance screening. Here's a point to remember. Aircraft finance usually fails at the moment economics overrule discipline. The preventative strategy is therefore straightforward. Even if the execution is hard, underwrite the operator, not just the owner. Match the finance structure to the lawful operating structure. Verify recordation and registry filings. Audit the maintenance status before and after closing. Track engine program obligations. Screen counterparties and routes. And revise the structure before a revenue idea, management change, or international trip quietly transforms the risk profile. In large turbine aircraft, the financing closing is not the end of the legal work. It's the beginning of the surveillance obligation and a need for ongoing follow-up. In short, the most expensive aircraft financing mistakes are rarely surprises in hindsight. They're usually visible in advance in the form of a sloppy structure, optimistic assumptions, weak records, and conduct that no longer matches the documents. I'd like you to remember this. In large turbine aircraft finance, the biggest risk is not leverage, it is misalignment. Thank you again for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Questions are welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues and answer your questions with precision.